Fundamentals of a living trust. A living trust is an estate planning legal document that contains your instructions and authorization for what you want to happen to your assets when you become disabled or pass away. But unlike a will, a living trust does not require probate to administer your assets, and control over your assets as well as the transfer of assets can occur automatically and immediately without court action. This document is one of the most powerful tools in estate planning to protect your intentions and desires regarding the handling of your assets if you cannot act. Should I have a living trust? Everyone who owns a home and/or other assets should have a living trust to protect themselves and their family members from unnecessary court costs and delays should they become incapacitated, disabled, or die. If you are married, you want to protect your spouse from unnecessary confusion, court delays, and expenses. Benefits of a living trust. With a living trust, you can avoid all probate delays and related costs and make life much simpler for your family members and loved ones during a medical crisis. Should you become incapacitated or disabled, a living trust will avoid the need for complicated and costly guardianship or conservatorship actions. Should you pass away, your spouse will be able to automatically and immediately continue forward without delay or unnecessary expense. Most importantly, when you and your spouse both die, your assets will pass automatically and immediately to your children and/or family members or loved ones without court action or unnecessary costs or expenses. This allows for quick distributions of your assets without the need for time-consuming and costly legal action. Living trusts save time, money, and future heartache for your loved ones. What makes a better living trust? Strategies and provisions. A trust agreement, being a legal document, must be written by professionals with the knowledge and experience to prepare such a legal document to cover all of your needs and desires. Arizona adopted the new Arizona Trust Code, which contains many provisions which could prove extremely beneficial to achieving your estate planning goals. The strategy put in these documents is just as important as the documents themselves. Arizona adopted the new Arizona Trust Code, which contains many provisions which could prove extremely beneficial to achieving your estate planning goals. It is imperative that you work with professionals that can make recommendations using the provisions of the new Arizona Trust Code as well as common sense, life suggestions in drafting your living trust, and other estate planning documents. Funding your living trust. Upon completion of drafting your living trust, it is imperative that you fund, or otherwise transfer title and/or beneficial interest or ownership of your estate assets to your living trust in order to avoid probate. If assets are not titled to or otherwise connected to your trust agreement, they are not under the Arizona Trust Code and will require probate upon your incapacity, disability, and/or death. This completely defeats the purpose of drafting your living trust agreement in the first place. This can happen as a result of poor planning and coordination with your professional advisor. Too often, we see incomplete funding of a trust. This can happen due to poor planning and coordination with your professional advisor. Alta Estate Services prides itself in drafting and coordinating a thorough and complete living trust and estate planning package after planning with clients. For more information on how you can implement the living trust into your estate planning strategy, please contact us by calling 520-797-1400.